Tom Abbate here with Parnham and Associates. Today I want to talk to you about motions to adjudicate and motions to revoke. These are motions filed by the state whenever someone is either put on probation, and that can be either deferred adjudication, which would go with a motion to adjudicate, or straight probation, which would result in a motion to revoke. Now, these types of matters are handled whenever someone has already entered a plea of guilty to an offense and has been placed onto some sort of probated sentence. With deferred adjudication, you've entered a plea of guilty. However, the court has not fully accepted that plea of guilty and entered it onto your record. They've deferred it until you complete the probation, and if you complete it successfully, they will not enter it. With straight probation, that's not the case. The plea of guilty is entered, you have a judgment against you, and you are found guilty of that offense. Now, when you're fighting a motion to revoke or a motion to adjudicate, you've got to keep some things in mind. The first is that it's a much lower standard of evidence. You don't get beyond the reasonable doubt standard. It is more likely than not. Okay? So it's not as, the hearing is not going to be as protective as, say, a trial would be. The other issue is that you don't get a jury for this. It is a judge ruled motion. The judge hears it, and the judge decides the credibility of the witnesses and whether or not to find that you violated one or more of the conditions of your probation. Now, with regard to what kinds of things will come up, these are going to be based on the conditions that you were placed under when you were put onto the probated sentence. This can be things like failing to pay fees, fines, and court costs. It can be, failing drug tests that you might have been ordered to do, failing to participate in any kind of treatment program or educational program that you are ordered to take, or, and this is usually the worst one, picking up a new offense. And we'll go through these kind of here in just a minute, but the thing to keep in mind whenever you're facing this is that the state may allege a laundry list of conditions that you have violated. Even if you were able to defeat all of them but one, you still lose. The standard of review on appeal is that so long as the trial court had a reasonable probability to find you guilty of one or more and of the conditions that were alleged to have been violated, and they did not abuse their discretion in doing so, the appellate courts will not touch the result. They will say that this was done properly, and you are stuck with whatever the resulting sentence or change in your life that occurred because of this. Most often, it's going to be converting you from a probated sentence to a prison sentence. So it's very important that whenever you're placed onto probation, you thoroughly read all of the conditions that you are given, and you ask any questions to make sure that you need to ask to make sure that you don't violate any of those conditions, because all it takes is just one mess up and you're going off to jail. Now, with regard to fees, fines, and court costs, there are certain exceptions to that. You can be behind in your fees, and they can't necessarily adjudicate or revoke you because the state on those types of issues generally has to prove that you were able to pay, but you were unwilling to pay. America does not deal in debtors' prisons, and it's not favored to throw someone in prison over a debt. Now, that doesn't necessarily apply to the probation fees that you're supposed to pay by the probation department. It really applies more to the fine that you were assessed, the court cost fees that you were assessed, things like that. The state has to be able to prove that you had a job, you were making this much money, and you just simply blew off your obligation. If they can't prove all of that, then they're going to have some trouble getting you revoked on that basis. However, the most common way of dealing with a motion to revoke from the state side is you get a new law violation, failure to participate, failure to take the classes, something like that, and then you add on the fees, fines, and court costs. And so, like I said, so long as they can find that you violated one of those items, the rest of them will be good, regardless of whether or not they were offered full proof at the hearing. The Court of Appeals is not going to touch it. Now, with regard to drug testing, this is something that you've got to make sure that you're doing. You are under the thumb of the court, and you are to comply with all of their rules. And if you are, doing drugs while you're on probation, it's not going to go well for you. And those ones are pretty simple for the state to prove, because they just need to get your probation officer in to testify that you were given a drug test and that you failed that drug test. That's pretty much going to be open and shut. If you abscond, you just completely decide not to come by anymore, or you don't participate in the programs, those are also pretty easy to prove. And so they just have to get your probation officer in, testify as to what you didn't do, and that's pretty much going to be the end of the story. Now, with regard to new law offenses, that's kind of a trickier one, because they have to prove that you did, in fact, violate the law. Not just simply that you were charged with a new law violation in most instances. It's going to depend on exactly how your conditions were worded, but a lot of times, if it's only a new law violation, the motion to revoke or adjudicate will be carried with that new law violation. And once you're found guilty of that new law violation, whether by a plea bargain or a trial, then your motion to adjudicate will be ruled upon, and of course at that point you're not really going to have a lot of a defense to it. So make sure you follow the law and you follow the conditions of your probation. Now, once the judge finds that you violated one or more of the conditions, they have a lot of options. They can amend your conditions and continue you on probation, or they can sentence you to prison. Typically, depending on the severity of what you did, is going to determine what the end result was. So if it's, you're behind on your fees, you maybe failed a few drug tests, but you didn't pick up any new law violations and you've otherwise participated, in all likelihood, you have a shot at getting your probation extended, at least with the first one. As if you keep coming back for this issue, the judge is probably going to get a little mad at you, and at some point is going to stop giving you chances. If it's a new law violation that you're convicted of, especially if that results in a prison sentence independently of the motion to adjudicate or the motion to revoke, you are probably just going to go to prison on that if they decide to carry it forward at all. It's really going to depend on the circumstances. Now, as far as with what amount of time the judge can give you, it depends on which one you had. If you have a deferred, the whole range of punishment is open to the judge. So, for instance, if you were given a deferred for a second-degree felony, the judge can sentence you anywhere between 2 and 20 years. He's not limited in any way. If you have a straight probation, this is going to be a sentence where you were sentenced to, say, 7 years of TDC, probated for 7 years, which means that you have a 7-year probation requirement. If you violate your probation, you are only looking at the 7 years. The judge is pretty much locked in to that number. Sometimes you can negotiate for lower, but if you go in front of the judge, they're typically kind of tied to whatever you were given on the front end. So you have to be very careful while you're on probation. You have to make sure you understand everything, and you have to make sure that you comply with everything, because this is, in some instances, your final shot.